All rise. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in Hayden against Pittendrich. Is that correct pronunciation? Pittendrich. Sorry about that. Our cause number is 1CA-CV 16-0125. Counsel, as I'm sure you're aware, we have read the briefs, conferenced this case before coming into argument this morning, and so you can bear that in mind in dispensing with any preliminaries as you begin your arguments. We are being audio and video recorded this morning, and that recording will be made available to the public online within the next couple of days. Each side has 20 minutes for oral argument, and the appellant may reserve as much time as you wish for rebuttal, subject to watching your own clock. And with that, if you're prepared, we can begin.
Good morning. John DiStefano for the plaintiff. The issues on appeal are, first, whether the trial court erred by granting summary judgment despite a disputed question of fact over whether the defendant's admitted breach of the contract caused Mary Hayden to be unable to pursue her rights in the family court. And second, whether the trial court erred by failing to make any written ruling at the summary judgment stage on the question of interest damages. I'll begin with the first issue.
Let's do that, and let me just ask you the obvious question. 88% of litigants in family court are pro per, and our system is designed to facilitate their receipt of justice. How is it that your client was unable to pursue a Rule 85 motion?
The 88% of litigants do not face cases of this kind of extraordinary magnitude.
But the argument is simple. I mean, the motion could have said something as simple on a single page as, I got $1 million, I should have gotten $25 million, or however many millions of dollars, because the business was sold for 52. That's enough to place the court on notice that there may be a problem with the decree. I don't understand what sort of complexity makes the court unavailable to somebody who has hundreds of thousands of dollars at her disposal.
Well, in the first place, the hundreds of thousands of dollars in terms of hiring counsel, our expert concluded that was not sufficient in terms of what the demands would be to actually pay counsel to proceed through the Rule 60 and back in the family court through trial. But to your question about proceeding pro per, I think it's not reasonable to expect a litigant to proceed pro per against, in a $58 million dispute against an adversary with virtually unlimited resources, with all the benefits of the sale of this company.
Well, it's not ideal, but you would agree with me, I'm sure, that there's no legal right to counsel in family court or in civil court.
Understood.
Would you agree with that proposition?
Yes, but that doesn't answer the question of what would be considered reasonable behavior as a matter of mitigation, which is the only basis that the defendant submits would stand in the way of this damages recovery.
Speaking of mitigation, what steps did your client pursue? Well, let me give you a couple of examples and see if there's anything in the record if she pursued these options. Did she consider or attempt to obtain a loan from anywhere to obtain the funding that would have come in the form of the $700,000 check? And did she seek to ask the family court just for enforcement, not the Rule 60C, but just to enforce the decree? Isn't it true that this was an order of the decree to pay? The property settlement agreement was an order of the court, was it not? So why couldn't it be enforced by the way any other item in a decree is forced, by an enforcement action to seek an order of contempt?
Well, to the first question, she did not attempt to attain a loan, and we submit that under the the law governing consequential damages, what was within the specific contemplation of the parties was she was relying on this money to provide her with the safety net she needed to deal with unexpected circumstances that might arise. So it was this breach that deprived her, not any, failure to apply for a loan or what.
Understood. There's no debate there's a breach.
But she should, under her rights, under this agreement, she should not have to subject herself to additional financial hardship, and the law of mitigation is clear. She doesn't need to go to some extraordinary transaction to remedy what the defendant failed to do.
How much did she need to file a Rule 85 motion?
How much did she need?
How much money?
Well, filing a Rule of 85 motion was not the entirety of what she needed to pursue to succeed in the family court. What the expert opined was that it would cost over $300,000 to file that motion and then get relief through trial and successive appeals. And we've seen in this case already that this defendant, with these resources and a particular type of approach to litigation, will stop at nothing, has been through 2 appeals already, and will litigate to any lengths to stand in the way of this recovery. So the evidence that the trial court doesn't mention in its ruling was well in excess of $300,000.
I don't mean to be difficult with you, but it troubles me that you might be asking for an appellate opinion that endorses the notion that the courts are essentially closed to those who don't have $300,000 at their disposal to file a motion and, as you say, secure relief, especially in a family court case. I've been a judge now for a long time, and I've never seen a FIAP on a $300,000 motion. But if we were to endorse that notion, what would we be saying about the system of justice in this state?
To be clear, we're not submitting that the motion alone would have cost more than $300,000. What we're saying is the overall costs of the litigation, the motion plus expert fees to appraise this company, to go through, the filings relating to that and those disputes and that discovery, in addition to trial over ownership, which remained in dispute at the time that the property settlement was concluded. So it wasn't just the motion alone.
But there was a property settlement. It was concluded. Your client voluntarily agreed to a certain amount of money as her share of a community lien on the business, right?
Right.
We know how much the business was ultimately sold for, right?
Right.
So I'm struggling to see how she was unable to find a lawyer to take that case. With a delta that big between the amount received and the amount in controversy, it's hard for me to fathom that there weren't thousands of lawyers available to take that case.
Well, the amounts of controversy, it's actually not, a straightforward matter that any lawyer, thousands of lawyers could pick up. We're talking about a sophisticated dispute involving business valuations as well as divorce ideas that it takes a certain level of qualifications. And she did, in fact, the only evidence is that she did, in fact, interview many firms which were unable to move forward, given her resources and given the complexity of the case. Right. And the defendant has provided no contrary evidence that there were lawyers standing by ready to take this, on a shoestring budget.
Well, and so I take it your point there is that you're going to a genuine dispute of fact or the lack thereof on the availability of lawyers, but a genuine dispute still has to be material. And I'm struggling to find any legal basis for saying that there was a legal necessity, a legal right to have a lawyer of a certain caliber take what is, in family court, a relatively routine case. Yes, the numbers are big, but Rule 85 motions are not uncommon.
Well, and remember, the money only becomes an issue once she learns about the sale, but for the first 7 months after the sale took place, she was deprived in that period of time of the ability to file because she didn't even know.
Sure, that's a different argument, though.
She didn't even know. And
it's a different argument.
It's an argument that we've made.
And she consciously decided to wait. Instead of seeking enforcement or suing immediately to try to collect that money.
At all times, she was deprived of the money, which is our position is without the money she couldn't move forward.
Let's go back to the mitigation, because you mentioned hardship, and it seems like you're suggesting that a party who is the non-breaching party doesn't really have to lift a finger in mitigation, because it would take extra effort. For instance, if there's a breach of a lease, then the tenant doesn't have to do anything or doesn't have to do anything to mitigate those damages, or the landlord doesn't, like they don't have to advertise the property, because that would take effort. That would be a hardship if they had to go spend money. I think or maybe I'm just misunderstanding your argument, but when you say hardship, what does that mean? Certainly a party that seeking to mitigate damages needs to do something.
Well, in the first place, we would question whether this is a proper mitigation defense at all, because what the defendant is effectively saying is you should have pursued some other optional avenue to recover against me. It's not an avoidance of the loss. The loss is still there. But in the second,
what is the loss?
The loss here is the loss of the right to go back into the family in the damage in the contract action.
Is it the loss of $700,000 for a period of 1 year, whatever the time period was? Isn't that the loss?
The deprivation of $700,000 until it was paid, and the consequential damages that flow from that. Yes, but in terms of what a party needs to do for mitigation, the case law is lenient as to what the standard is, because it is, after all, the defendant who put the plaintiff in this situation. There's no Monday morning quarterbacking, and it is a hardship to go into, to stride into a $58 million piece of litigation without counsel, without any idea of what the merits of it might be, what the standards that need to be met, what types of evidence you need to present. All of that, it would be fairly insane. And if you look at the
understood, I mean, especially in light of the contract that was signed that says at least 5, 6, 7 times that, both parties are represented by counsel. Both parties have had the opportunity to review all assets. Both parties are entering into this and believe that it's it's an equitable agreement. The court makes that finding. I mean, anybody would say that that's a tough burden to overcome. So did it do? Let me ask you this: asking the obvious, did it do any good to wait 22 months to file the Rule 60C motion? I mean, it was the same result.
In the end, it didn't. But our position is that she had no reasonable alternative, because she had a very limited supply of cash that was tied up in retirement, needed additional money to be able to take this kind of risk on legal fees that might not ultimately pay off. And the contract itself says, in terms of the idea that she waited, the contract itself says that the failure to insist on performance in paragraph 19,
sure.
The failure to require strict performance is not a waiver of anything.
In the time we have left, though, I'd like to explore your theory of consequential damages and your definition of the doctrine. Is it significant in your mind that you're alleging that consequential damages are the loss of an ability to pursue this litigation? Or would your theory be just as valid if you chose as your measure of damages the loss of an opportunity to make an investment in some stock that was appreciating at the time, or to start a business, or to do any number of things that one might have done with the money that might theoretically have resulted in a significant profit?
No, these damages arise directly from special circumstances that were known to the parties at the time the contract was made and were within their contemplation, because the purpose of that acceleration clause was to provide a safety net, and all of the finances of both parties were on the table.
But my question is a little different. If you had would you agree that you could not select as your measure of damages the missed opportunity to invest in a certain investment at that time?
Yes.
You would agree that that would not be appropriate?
I would agree.
Okay. So then, I don't mean to put words in your mouth, but what I'm hearing you saying is that there must be some foreseeability to the consequence that gives rise to the consequential damages.
Right. The reason that the investment damages wouldn't work would be because the outcome of that investment would be speculative. But
the outcome of this litigation is fairly speculative too.
The vulnerability of, and our expert says not. Our expert says that was probably a valid Rule 60 motion. But the category of loss that was foreseen was the loss within the risk that was created by depriving her of these funds. And if you look, there's a case that comes to mind is Technology Construction Incorporated versus City of Kingman, 229 Arizona 564. That one dealt with delays in construction, and the issue was fluctuating prices of materials. Hurricane Katrina happened. Hurricane Katrina, no one saw that coming, but it affected the prices of materials, and that was just as valid a form of consequential damages as any other variation in the price of materials.
But in your, let's keep it to your case. In your case, you're saying that there was some foreseeability to the harm that would be caused by the breach as it related specifically to unwinding this property settlement agreement.
Yeah, particularly in view of the fact that, in addition to the divorce disclosures, the Petsky-Prunier valuation of the company for $50 million happened 6 months before the decree was entered. So that was known to the defendant as well. He knew exactly the risk that he was creating for the non-breaching party, for Mary Hayden.
Do you think that it was a purpose of the contract to fund, for the defendant to fund litigation against himself? I mean, he breached it, no question. We're not excusing that. But it was not, as I understand it, a purpose of the contract for him to then fund subsequent litigation. It was a purpose of the contract, I believe, as you said, to provide a safety net.
A safety net for sudden emergencies that might arise and place Mary Hayden's rights at risk. It just so happened that in this case, the emergency was, that the sale of the company without disclosure on a basis that would support a Rule 60 motion.
Okay.
Counsel, are you aware of any case in the country, or in all of your research, are you aware of any case that has found a consequential damage, like in any situation even remotely similar to here? In other words, inability to finance litigation. Have you stumbled across any case?
Inability. Well, I think the closest analogy is
the consequential damage.
Is the loss of a claim.
Well, but that's different. This is not the loss of a claim. This is the loss of the ability to fund litigation in the manner in which some expert says it should have been funded. Have you found a case that says that?
No. What Arizona law says is that if the defendant has special knowledge of the non-breaching party's financial hardships, that there's those two Western Union cases, Sharp and Morris from the 1932 and 22, that in one case the Western Union knew about the financial hardships and the breach of the contract to provide the money left them exposed, and the other case they didn't, and so they weren't exposed. But that's the way consequential damages work when you have knowledge of the special circumstances. And I'll reserve the remainder of my time.
Very well.
Thank you.
Good morning. May it please the Court. My name is Scott Holcomb. I'm an attorney here on behalf of Stephen Pittendrich. I think you've hit the major issues in this case, and that has to deal with the fact that there is no explanation, there is no issue of material fact as to why Ms. Hayden could not file an action to set aside the PSA if that's what she wanted to do. But she didn't, and that was her choice. And that doesn't bring any issue of material fact before either the Superior Court or this Court to overturn the grant of a motion for summary judgment. And that's for multiple reasons. But I think the Court hit upon the very first logical reason is most litigants could file a motion. And this is where it really gets different. Their whole argument is they couldn't complete this complex litigation. That's not the issue at all. The issue, as the Court properly noted, is could Ms. Hayden have gone out and filed the action? And most importantly, that issue has already been resolved against Hayden. And it was resolved on the Rule 60 motion in the Rule 60 order.
85.
Well, we can use Rule 85. They started down the Rule 60 motion, and it just was simpler to keep the Rule 60. But Rule 85, that's correct.
I agree with you. They should be numbered the same. But go ahead.
Right. But Rule 85, the Rule 85 motion, the order on that specifically resolved the exact issue that they're putting before this court.
Although part of that was on the basis of timeliness. And I've got to admit, it seems odd to me that a party can rely on a short time bar to shield his own potential fraud. And this motion doesn't facially lack merit. Do you agree?
Which motion?
Well, a Rule 85 motion that said my share was $1 million, the business sold for $52, at least gives rise to a superficial inference that disclosures might have been inadequate. Would you agree?
Superficially. There's a lot more to it, and I think that's part of the thing that I think is getting beyond the briefs. It's in the briefs. Make sure that this is clear. That superficially you could brought that motion, but the Rule 85 order was entered not based upon the merits at all of the motion. It was granted specifically on the issue that there was no satisfactory explanation for Ms. Hayden's delay of 22 months between the time that she knew the sale and actually filing her action. And the specific arguments that were made by Ms. Hayden are exactly the arguments you just heard today and were presented in the Court of Appeals. And in fact, I want to make sure you caught this nuance in the record, is that the discovery that was the basis for the motion for summary judgment, the depositions, the emails that came out that explained that there was a specific tactical decision by Mary Hayden to delay until she got all the money under the contract, that discovery was taken not in this case. That discovery was taken in the Rule 85 motion. And in fact, if you look, the Rule 85 motion was filed on 3/16/2009, March 16th of 2009, and the order didn't come out until over a year later. The reason it came out over a year later is we were successful in getting a motion before the court to allow us to take discovery, specifically on the issue of whether there was any reasonable basis for her to delay those 22 months. And that's
Of course, if we accept the appellant's version of the facts, there was concealment of the sale, which in part facilitated the breach, but in part took everybody out beyond the Rule 85 time frame anyway. You couldn't have filed a timely fraud motion because the fraud itself protected against the necessary knowledge.
Your Honor, with all due respect, each of the factual predicates there are incorrect. And let me walk through them. Sure. First, most basic factual predicate. The Rule 85, now I'm mixing the two numbers together, the Rule 85 motion on fraud, the 6 months limitation never applied because the sale didn't happen until 10 months afterwards. Okay. Second, the motion that they filed wasn't based upon fraud. In fact, they argued that because they didn't want to deal with the 6 month limitation, which didn't have any application to begin with. Their motion was filed under the subsection 6, other circumstances, and that's the argued. And the, quote, non-disclosure of the sale didn't apply at all after she discovered the sale on May 4th, 2007, and she waited the 22 months. So the whole issue before the court on the Rule 85 motion had nothing to do with the merits, with the substantive, had nothing to do with even the delay up until May 4th of 2007. It had everything to do with, but what was the effect of her tactical decision to continue taking the funds and wait 22 months to file the action? That's exactly what Judge McVeigh ruled upon, and they did not appeal that ruling. And his ruling, not only under issue preclusion, as we've briefed, and they really haven't responded to that argument at all in their brief. Issue preclusion, claim preclusion, and law of the case all provide that the only issue that they've raised, was it reasonable for her to wait that time period? That only issue that they've raised is not a fact question. In fact, as we mentioned in our brief, we would be entitled to a jury instruction that you are instructed that there is no satisfactory explanation for her delay in filing the motion, and that her delay was unreasonable. That's the only issue they've raised. And we're entitled to a jury instruction that says, jury, you have to rule against them as a matter of law of the case and what's already been determined by the Judge McVeigh in the Rule 85 order and by this court. This court specifically held that it was unreasonable and that it was her tactical decision to delay, her choice, that caused her to lose that motion. And in fact, this court went further in the memorandum decision and held that her choice to not move forward and to continue accepting the benefits of this contract after she knew of the alleged fraud precluded her from recovering any damages in relation to that. It precluded her from rescinding the PSA and the order, which is the only basis under which they could recover these damages. And that's been the frustrating part. This case has been going on now for 12 years, since the divorce. This is our third time up on the Court of Appeals.
Well, true. And the first time, I might agree with you to some extent that it appeared that the court was sending him back on a narrow remand. However, on the second go-round, after the special action, I read that order as much broader, sending it back for a full determination or a full. Our court said we're not expressing an opinion, but we sent it back for a full litigation on all damages relating to the breach of contract.
Correct.
Did we not? Yes.
You did. And this case is not about whether theoretically they could recover some form of proper consequential damages. But the question that came from the bench is perfect. There is no law, there is no case, there is no theory under which a person can go in and say, my consequential damages for breach of a contract is to have my right to go in and rescind the contract and recover damages that violate that same contract. You don't get to pick and choose what provisions of the contract you get to enforce. And paragraph 23, there's multiple paragraphs, as mentioned, both in the order and in the PSA, that preclude the action that they're trying to take. But specifically, paragraph 23 of the PSA provides property and assets awarded to husband. Husband is hereby awarded as his sole and separate property, free of any claim from wife, the assets described as 1, all shares of capital stock of Impulse Response Group, Inc., issued in the name of Stephen Pittendrich, and any other interest of whatever type he and or the community has in the business. They keep defending against us and saying, oh, we're not trying to rescind the PSA, we're not trying to rescind the order, we're trying to enforce it. Well, to enforce the contract, you enforce all the provisions of the contract. And the most important provision in this one is that whatever else may be the interest in Impulse belongs to Steve Pittendrich as his sole and separate property, free and clear of any claim by wife. And they can't avoid that by saying, oh, this is consequential damages. But you also point out this is not foreseeable. In fact, the exact opposite. What was the purpose of this contract? The purpose of the PSA was to settle these issues between these two parties. That issue was settled by the contract. Now they want to go in and say, oh, we're going to enforce the contract, and now but we're going to unwind the very deal that gave rise to the payments. And they're not offering to give the payments back. But all of this are arguments that we've had in front of this court already. And this court has determined you cannot rescind the contract. You're not entitled to any interest in Impulse. You can't. There's no fraud claim, none of that. You have a simple breach of contract claim with all proper damages that can come from that breach of contract claim. But you cannot, under any circumstances, recover any interest in Impulse. And that's why we filed the motion for summary judgment. And Judge Brown, to your point, when this got, on the special action, it got remanded to the trial court, we did exactly what this court ordered us to do. Take discovery and determine what damages could be recovered. And you don't have to take our word for what damages they're seeking to recover. You have their words. Mary's damages, this is out of their disclosure statement. Mary's damages related to Mr. Pittendrich's breach for failure to accelerate the remaining monies owed under the agreement, the PSA, equal at least 1/2 of the marital estate's interest in the sale price of Impulse, plus interest on the amount of the statutory rate of 10%. That damage is specifically precluded both by this court's ruling in the decision and by the express terms of the PSA. The response to an interrogatory. Again, we've focused our discovery on this exact point. Mary lost her ability to reclaim half. This isn't even more telling. Mary lost her ability to reclaim half of the marital community's interest in the $58 million sale of IRG, Impulse, a direct and consequential result of Pittendrich's breach. That damage is not a consequential damage, as the court properly pointed out. But even more directly, it is exactly that damage that this court has already ruled cannot be recovered. And even if you went past the ratification of the agreement, which you said that you can't recover any of these damages, you'd have to go to the enforcement of the agreement. And if they want to enforce the payment provisions, they don't talk at all about paragraph 23. We get to enforce paragraph 23. They can't recover that damage.
What is your position with regards to the interest damages?
Our position is twofold in relation to interest, Your Honor. First, we argued the interest damages in our motion for summary judgment. They didn't respond at all in the response to the motion for summary judgment. That was a waiver. They conceded that we were entitled to the credit for the settlements with the other parties who were sued in the same lawsuit and whose settlement related to the same damages. So we are, our position is at first,
I thought it was raised. Well, we'll let counsel address that. I thought it was raised at least briefly in the response, but we can confirm that. But
all they said was it was about the numbers. But it was about the credit.
Can you cut right to the chase, though? Where in the record does it show that the amount of what I might get the numbers wrong here,
sure,
145,000 and whatever change additional on top of that, whatever, has that been paid in other words, have they received it? Has the check been cashed?
Yeah. Are you talking about a check from Mr. Pittendrich?
Yes.
Okay.
Payment.
No. What happened was we tendered the payment, and it was actually about $133,000 and change, because the court determined properly based upon the specific direction of the Court of Appeals that it was $144,000 and change. We rounded it up to $145,000. At that time, we had an attorney's fees award in our favor of approximately $11,000. So we tendered a check from that.
And you put in the UCC language saying in full satisfaction?
No, we did not. We did not. And in fact, if you look at the correspondence going back and forth, we originally said, we believe that this is the payment in full. Here's the check. They returned it to us. We sent the check back and said, we think this is payment in full, but we are not asking you to agree that that's payment in full. Just cash the check. And they refused to cash the check. And that tender by us stops the running of any interest. What happened afterwards, and they talk about this as being nefarious. No, it's not nefarious. It's a basic law in mathematics. Is after we let them hold the check and kept asking them, cash the check so we can get this out of the way, they refused. We then get an order from the court, a final judgment, that says we don't owe any interest. Specific hold. So we have a final judgment of the court says we don't owe any interest.
But that's an issue they're raising on appeal. So,
but that's the time. If I may just finish it. That is why we then stopped payment on the check, because they had already received the money. So we tried. Lord knows we tried to have them cash that check.
So disagree that the $10,000 attorney's fees that went away. That award
Correct.
went away.
Correct.
In light of this court's decision and as a result of the special action, or it was confirmed at some time that
Correct.
fee award went away.
It was in this special action, Your Honor. It was in the special action that fee award went away. That, but we had tendered that check before the special action came down.
If I'm hearing...
So...
Well, go ahead, finish your thought.
I apologize. And so, focusing in on that, the most we could be held interest for the interest on that was for some period of time where on the $10,000, because we had tendered unconditionally everything but that $10,000, the $11,000. So we had at that time tendered it all. At this point now, but then we are entitled to a credit of $650,000, and as pointed out in our brief, again, basic mathematics, under even their calculation of the most the interest could be, and it's wrong because it goes beyond the $10,000, is $240-some thousand. They had received $650. They've been more than fully satisfied by that other settlement. And go ahead, Your Honor.
Well, okay. I was going to say, as I interpret your position, you've got an accrual date or an accrual stop date issue based on the tender. I understand that. The credit is a theory that I have to say I've never seen applied before. Do you have any authority?
Yes, Your Honor.
On this?
It's noted in our brief, but there's the Pasco Industries, Inc. versus Telco Recycling, Inc. case, which is cited in our brief. You want the Arizona? No, that's it.
We've got it.
You've got it. And that case...
I guess I should have phrased my question better. What's your best case on this theory? Because we have obviously seen your table of authorities.
That one in the Grover case, that's also in our table of authorities. And those cases make, and this is an important, again, nuance that you have to really get out of the record. The only claim left in this is for enforcement of the contract. It's not a tort claim. The fraud claims, misrepresentation, those are all gone. Those claims don't exist. As a straight contract claim, the Arizona law is absolutely clear. On a straight contract claim, the collateral source rule doesn't apply, and are entitled, basic contract 101, you're entitled to one recovery, and once you've received a recovery, you're not entitled to anything more. That's the basis of this rule in contracts. They've already received $650,000 from their attorneys and from their expert, which is
Counsel, those involve tort claims against those entities.
And actually, that's why the Pasco case is critical, because the Pasco case dealt with tort claims, contract claims, and antitrust claims, other claims. And the settlement by the other parties was not on the contract claim. It was settlement on other theories, other claims related to the same damages. And the court held that was properly set off.
Nobody has paid damages to make your client, to make the appellant whole for your client's breach of the agreement, right?
No, we believe they have, because they were sued in the same litigation for the same at the same lawsuit, in fact, that they filed against us to recover the monies against Mr. Pittendrich. They actually filed a motion in the court saying, if we're granted the relief on the Rule 60, the Rule 85 motion, then this complaint is moot, because the recovery will be the same. It'll be the same recovery, and our position is that they have received those damages and more.
I understand. Are there any other questions from the panel? No. Okay, I think we're out of time, but thank you.
Thank you, Your Honor.
Thank you. I'll quickly touch on the interest point. We did respond on page 3 of the motion for summary judgment, and the pleadings make it clear in terms of what the record needs to support for summary judgment. Paragraph 97 of the First Amendment complaint pleads breach of contract solely against defendant Stephen Pittendrich, and nothing to do with those other defendants. And their settlement agreements, the scope of the releases and the recitals make clear those claims against those defendants related to things that happened during the divorce with the valuation, et cetera, and they had nothing to do with an independent decision after the divorce to breach the contract and fail to pay on time. Now, as to the issue of issue preclusion, this again was dealt with in the brief on pages 17 through 20 of the reply. This was not part of the trial court's ruling. It didn't rely on issue preclusion, but the Rule 60 ruling was not preclusive. The breach of contract claim was not before the court. Mitigation standards were not before the court. It was applying a deadline. The other thing, as far as the timing of the Rule 60 motion goes, this was a highly unusual piece of litigation. The sale occurred more than 6 months after the decree, so the issue was not the fraud basis for Rule 60 that you would have to file within 6 months. The issue was an inequitable distribution, and again, highlighting the complexity and the unusualness of the standards that would make it really unreasonable for someone to proceed without sound advice and analysis and representation through the entire family court proceeding.
Would your argument apply equally to the missing of a statute of limitations? What if your client couldn't find a plaintiff's lawyer that an expert thought was good enough to bring a civil action and just let the statute of limitations lapse?
That's exactly.
We overlook that too? I mean,
that's exactly what happened here. We're not trying to bring an untimely claim. The contract claim is timely. The contract claim is timely, but it's predicated upon the loss of her ability on day one. If the money had been paid, this is the but-for world.
Our law requires that you preserve a claim. It doesn't take much to preserve a claim, to make a claim in a timely fashion. It doesn't require Covington and Burling to file a complaint and stop a clock from running. It seems to be your position that until the tank was fully loaded and your client was ready to proceed start to finish, that deadlines just sort of stopped.
No, and that goes to part of why the Rule 60 ruling was not preclusive. The standard for applying the court rule is not the same standard that we apply to the rights of an aggrieved party operating under a contract, where they have a specific expectation of getting money on time. And she bargained to have that money on day one. The day the company was sold, she should have received the money and been informed and been able to vindicate her rights. And for 7 months, she had no ability. Only then, after that point did she learn, and she still didn't have the money after that. But for 7 months, a jury could find that, had the contract been honored, she would have been in a position to and would have asserted the rights that she needed to assert and preserve that claim on a reasonable basis. Finally, as to the defendant's point about rescission, as we've explained in the briefs, the plaintiff is seeking to enforce the contract. I think both parties agree on that. The measure of damages is simply the value of the claim. It's a damages case. We're not pursuing an asset. So the releases and the allocation of property under the decree simply don't apply to this claim, which accrued after the decree and the settlement agreement went into effect. Are there any further questions, or should I submit?
I think that concludes the argument.
Thank you.
Thank you to counsel for both of your arguments. The matter is now under advisement. We will issue a written decision in due course, and the court stands adjourned.